Hello, everyone. I hope we're well. Let's all settle in while we wait for the others to join. Looking at the comment section, I've put my plan for today in there, and it seems rather ambitious. But first, I hope we're all well. Let me know if you can hear me in the comment section. Can you hear me? Okay, great. Hope we're all doing well. Okay. Yeah, talking about clear, the weather here, it's, I mean, there's no sun, but it's just, mm, it's not sunny. It looks dull, but there's no rain. How is the weather in Hong Kong? Okay, good, good. So what I'm going to start with, as I, very hot. I could do with some hot here. It's not hot at all, and I don't like that. So, like I said in the comment section, I have my plan is to do four things today. Four, ambitious, but let's see where we get to with this. Because remember, one of you raised the point when we started that we've got six lectures, six topics, and we have to cover this within five days, five lectures. So there has to be that overlap. So my plan today is to cover the rest of the answer to to question four that we started 2 days ago, and also move on to discuss the SGSA. That should be pretty straightforward. It's a really good question for students. Lots of students do really well with this, providing you follow the steps that I'm going to share with you today. And we're also going to be answering the questions on SGSA, which are questions five and six. And then we'll move on to the final thing I hope to cover today is the slides, are the slides on the Nemo dot principle. So hopefully when we come back tomorrow, we'll be able to answer the questions on that. So yeah, without much ado, let's just get cracking. Now, I think on Tuesday we stopped at talking about identity. We talked about section, the section on the identity of the goods. Description, yeah, thank you. Description, identity of the goods. Yeah, section 13. But remember, Lord Chi, it wasn't section 13 because we're looking at this. This is a consumer. I wanted to say section 13 when I was struggling to remember where we stopped. But this is not section 13. Good. CRA, yes, because it's a consumer contract. So now I want us to proceed to talk about quality and fitness for purpose. I'll share the question. So we're having a look at that as share. Let's see. I think I need to share the question first. So I've got documents, screens, revision questions, share. So we can all see that, hopefully. Yeah. So we're looking at this question. We've talked about identification if it doesn't meet the description of the contract. Now we're looking at whether it's fit for purpose or the quality is great. So the relevant section again is section 9. This is a term of the contract. Remember, when it comes to consumer contracts, the law provides more protection. So they're never going to get something lower than what you get as a trader. So looking at section 9, it defines goods as being of satisfactory quality. It's impari material with the provisions of section 14.2 in the sense that it just copies it all down. But remember, you don't want to make the mistake of citing the section on SGA, but you can point it out that it refers to it uses the same terms. It talks about fitness for purposes, taking into consideration the price, all the relevant circumstances, including the statements made by the seller. So it's basically in pari material. Talks about appearance and finish, freedom from minor defects, safety, durability. So it's similar to the provisions. But what we want to talk about here is that in the SGA, there was the addition of the word all, ALL, and this was a change from the previous test under the statute. So the question we want to ask ourselves here is, does the lack of a DVD connection in this case, because he said he couldn't play a DVD, does the lack of a DVD connection, does that mean that it doesn't meet the standard that you would expect? Does that lack of DVD connection and the provision of only black and white pictures infringe on these requirements? You might want to point to what Atiya said about this. He was of the view that the courts are unlikely to find a failure to meet this standard where the goods are put to unusual use. So the question we want to ask ourselves is DVD a requirement in today's world? Uh, I mean, it depends. So you might want to ask, what would a reasonable person expect? What would they expect? Most TVs in the current age are expected to have external input beyond the basic TV aerial, and as such, most must have the HDMI, the SCART inputs that could operate DVD. I mean, you would think that, but some people might argue the DVD has been phased out. No one's talking about it anymore. So let's see what comments you've got there. Yeah, must cor I'm not sure. Yeah, yeah. Or need to, they don't even have DVDs. So that's a very good point. But if this is about something that you do not know about, you just want to go back to the argument that what would a reasonable yeah, yeah, you're right. You're right. Not many people are using the antenna, even in the current age, because everyone's got access to a Wi-Fi, and that's all you need to watch TV. So you might want to argue that this is not a bridge. She's trying to use the TV for a special purpose, and if that's the case, then we need to look at another section. Did she make a representation of this to the seller at the time? Was there reliance? So like I said, when you're answering these questions, you realize that there is no right or wrong answer, provided that your arguments are logical. So you can say in the current age, this is not what the expectation is, and you will be right. And someone might say, yeah, we would still expect to see that. And they're also right. It is based on what they think a reasonable person will interpret would call this. So in this case, the TV is also black and white. You would say, yeah, that's not good enough. That's not what a reasonable person would expect. It's not fit for purpose. No one watches black and white anymore. At least I don't think I want to watch black and white TV. So the fact that the TV, if we can argue that the lack of DVD is still okay, but what about the black and white? That's flawed, isn't it? So we can argue that the TV does not meet the criteria, does not meet that quality and fitness to purpose. Now, you want to proceed by talking about the nuance. So this is where how you can distinguish yourself, because people will just go through the main argument and say, yes, it's not, it's this. But you have to look at the complex issues, complex areas. And in this case, you want to talk about maybe second-hand goods are to be judged by the same test as new goods. And for that, we've got the authority of business appliance specialist versus Nationwide Credit Corporation. And the question there is, a reasonable person, would they expect the same perfect standard for what she has paid? So if you've paid a lower price, would you expect that second-hand good to be the same as the one that is brand new? That could be relevant to the argument in this situation. In this case, she's buying a shop display brand. So what do you expect? Maybe minor scratches, or because people would have touched it, wouldn't they? And the authority for that is the Hansa node. So the price paid, of course, will be a factor in the standard to be expected. If the defective goods have a similar marketable value, they are likely to meet that standard of satisfactory quality, even if they are not perfect. Even if they are not perfect, they are likely to meet that. And the authority on that is Brown and Craig's. But if the party has paid for an item that is at the top end, is a luxury item, that leather luxury watch one of you mentioned on Tuesday, if they've paid that higher, expensive, more expensive cost, they've paid a lot of money, then you would think they should get more in the quality of their goods. And we have the authority of that is Rogers versus Parrish, and also Clegg versus Anderson, or Clegg and Anderson, if you like. So in that case, new goods were sold. New goods were sold at a reduced price of 699, but their value pre-sale was £1,000, and this may indicate that Christine was entitled to inspect. So how much did she pay? Yeah, she paid maybe £300 less. So there's that reduction, and this may suggest that the appropriate standard it should be lower, but we have to assess this. What would a reasonable person expect? So you have to keep going back to the reasonable person, because that's the test. It's the test of a reasonable person. So 399 for a TV is not a throwaway price, and there will be some expectations of the standard. 699 rather. There will be some standard of expectation for the working TV. I think now some of them are being sold for 400, 300, 500. So that's still a lot of money. It's not a throwaway money, so you would be expecting something of quality. By all means, you would not be expecting to get a black and white TV if that's not what you've bargained for. Now, talking about the crack at the bottom of the TV, of the screen. And you can see what we're doing here. We are picking up on each of the issues raised, each of the minor sub issues. So we talked about the black and white. We've talked about the lack of DVD capability. Now we're talking about the crack at the bottom of the screen. This is what I'd like you to do. This is what we would like you to do in the assessment. You can, I am sure you do that. You can go in with an highlighter or a pencil or a pen, and as you're reading the question, you're using that to underline some of the main things you think you'll be picking on. You can even number these one, two, just so you've covered all of that. Because one mistake I see students make is that they cover some and do not cover the others. I can understand if you're pressed for time. Do you get the point? Like if you're struggling to meet up, but maybe one or two lines will still let us realize that, oh, this, in fact, when we're marking, we know students that had to stop because they were out of time, because you can see students stopping mid-sentence. We know that, and we know you're working under serious time constraints. So try to cover all the start with the major ones and cover the minor ones as well. And if you're struggling to know which ones are the major ones or which one are the minor ones, you, when you're coming to a conclusion on each of this, so there's section 14, there's not, sorry, not section 14, section 11, CRA, and then there's section 9. These are the major things, and there are some minor things under those as well, like the crack, the black and white, the lack of DVD. So now going back to talk about the crack, there's a crack at the bottom of the screen. New goods should be free from minor defects, but Christine saw goods that are in box. She didn't choose that. She decided to buy an X display TV. So it may be expected that there will be minor marks. But in this case, it's a 2-inch crack. 2 inch is quite long, if you like. I don't think that on a TV screen, that's a lot. So a 2-inch crack on the TV screen is likely to be considered as something more than a simple minor, simply a minor defect. It's not that minor. And there's the issue with safety. The law on that is if the goods are not safe, there's the high likelihood that they're not of satisfactory quality or fit for purpose. In this case, the goods should be safe in their normal use, and we've got the authority of Bernstein v. Palmson, mottos or yeah, Palmson mottos, and then we've also got the case of Lee and York, Coach and Marine. You can see someone asked a question before we started earlier that do we need to cite the facts of cases? And I told the person that that is only if you think it's material to what you're saying. You need to advance arguments and you may not have the time to cite the facts of the case. But you see what I've done here? I've cited the principle and then I've cited the cases in support of that without going into too much detail. In a vast majority of the cases of your writing, you will not be required. You do not need to go into the facts of the case. But there might be some, we're going to see how that plays out. But what we've done so far here is I've said goods should be safe in their normal use. Bernstein versus Palmson mottos, and Lee versus York, Coach and Marine. So I've not gone into the fact. You can just do that. Now, the fact that the TV is smoking during use indicates that there is a problem with safety, or at the very least, there's a defect, or the goods is not safe, is not suitable for all purposes. If the goods are unsafe, there could be a risk of fire. It is clear that that is not satisfactory quality, right? That's not satisfactory quality. And moving beyond that, moving on to the next point of durability. The goods should be durable and last a reasonable period of time. What is reasonable is a question of fact. I want to quickly have a look at the comment someone put there. Can I type? What do you want me to type out? Do you mean the case? The case is for safety. So that's yeah, I'll do that now. Bernstein v. Palmson mottos. And there's also the case of E. Lee v. York, Coach and Marine. Yeah. Okay. Oh, someone beat me to it. Okay. Uh, all right. Yeah. We'll crack on then, won't we? So the goods should be durable, and you see that we're moving on to the next point. Thank you very much, Law. Yeah, thank you for putting that there. Yeah, thank you. So moving on. Goods should be durable and should last a reasonable period of time. And anytime you see the word reasonable, you know the law is trying to cr- allow that flexibility to accommodate all sorts of cases. So what is reasonable is a question of fact, and it depends on the circumstances and the nature of the goods. Again, that's another principle of the law. Has anyone got a case on that, on what is reasonable? Have we got any case on that? So that's one authority, Lambert v. Lewis. Goods, what's reasonable is a question of facts and it would depend on the circumstances and the nature of the goods. But we should note that when one buys second-hand goods, you know, you buy what you pay for. You get what you pay for rather. So the goods are unlikely to show the same level of durability as new goods. And the case for that is Crowder, Crowther, and Shannon. But again, the question may be affected by the quality of the goods that you buy. There are authorities on that as well. You can look at the slides. So it would depend on the type of goods, really. So you might expect a Sony TV to be of better quality and more durable than a cheaper brand like the Medion or yeah, cheaper brands. So Christine in this case did not buy a second-hand goods, even though she could do that, but she didn't because she was expecting a better quality, and she was told that they were as good as new. And we would have said that she relied on this. She was told they were as good as new and had never been switched on. So we would expect some quality there. You would expect it to last significantly longer than 2 weeks. It's not food. 2 weeks, that's too short. But now it's not very clear. How do we prove that they've not been turned on? That's a very difficult one to prove. And I don't think it really matters whether they've been turned on or not in the scheme of things. So it should be noted that Section 9(4) provides that the buyer cannot complain about any defect that has been brought to our notice. And again, this is a minor point, a nuance that you would do well to point to in answering the question. But in this case, we're not sure if Roberto made any representation to uh, any brings anything to our attention. So we're going to assume all those defects were proved. Uh, uh, they've been breached and she didn't know about this. So in addition to when the buyer has examined the goods, she cannot complain of any defects. We don't think on the fact it doesn't say whether Christine inspected the goods. If she did, she should have seen the crack, but we don't know that. Yeah, the crack would have been apparent. And another point is the issue of warranty. We've touched on that in the previous question or slides, that the warranty does not reduce the right of the buyer. So the fact that you have a warranty, the manufacturer is going to repair the goods for you within a period of say 2 years doesn't make it not of satisfactory quality. If it's not satisfactory, it's not satisfactory. So the warranty, the provision of warranty is in addition to the rights of the buyer, not a reduction of it, not a detraction from it. So the authority on that, on warranty, is Rogers and Parish. Rogers and Parish. Rogers. Good. Yeah. Thank you. Yeah. Okay, I'm seeing the chat. So Rogers, Rogers, and Parish, Parish. Yeah, okay, good. Yeah. Thank you all for your help. So, taking into account all the issues that we talked about, all the issues, the DVD, the crack screen, the black and white, no representation made to her, did she have the right to respect? You would agree with me that it's more likely that these goods are not of satisfactory quality. The TV is not of satisfactory quality, even though it's an X display and so cheaper. In addition to CRA, so now you've made your conclusion, right? And you're talking about, in addition to the CRA, Section 10(3) implies a time into the contract that if some goods are sold in the course of a business, they should be fit for purpose and for the purpose not for which they're used. We would need to ask Christine whether she told the seller that she wants to use the DVD with the TV, and that is if your argument is the DVD is not a normal, like someone argued, the last TV they bought didn't have a DVD player. So if that's your argument, if you're saying the TV doesn't need to have a DVD player. That means she's using it for a different purpose than the purpose for which the TV was being made. And in that case, she would need to have informed the seller of this specific need. And this is similar to section 14(3) of the SGA. Section 10(3) is impari, is just very similar. So we need to ask her if she told him this. If she did, and then relied on the salesman's comments on the TV being able to play the DVD, then there will be a breach of section 10(3). But if she chose this model without relying on the salesman in any way, then she will not be able to claim under section 10(3). But watching DVDs may not be the only purpose for which a TV is being made. So it's likely she would need to have been very clear, very, very clear on what she wants to use a TV for. And the authority for this is Priest, Priest, and last, Last, last. Now, you've talked about there's a likely breach of both sections, both provisions, um, not meeting, not complying with the description, and also not being fit for purpose. Let's talk about remedies. And this is where the law, thank you, Clyde. When we're talking about the remedies, you want to see here that the remedies are a bit more expansive compared to what you get as a business if it's a B2B contract. And you want to point this out, right? If it's a business to consumer contract. Now, if there's been a likely breach of Section 9 and the other Section 11, 10, etc., what are the remedies available? The CRA Section 19 says that there are tiered remedies. First, there is a right of rejection. Within 30 days, you can reject for any reason. You can reject within 30 days. And after that, you can also ask for repair or ask for the price to be reduced. And finally, there's a final right to reject. Remember what caused confusion the last time. The doctrine of acceptance does not apply to consumers. So the fact that you've kept the TV for longer doesn't matter. You're just enjoying yourself as a consumer. You've got lots of rights here. You're not deemed to have accepted the TV. This has been argued to encourage consumers to just hold on to the products for as long as possible. So the doctrine of acceptance does not apply. So if she is exercised her right to reject within the 30 days, I think it was she asked for the goods to be repaired, for the TV to be repaired after 2 weeks after 2 weeks, yeah, 14 days. What that means is that out of our 30 days, the time stops on the 12th day because that 14th day, because that's when she said she wants to return the TV. And the TV was repaired, it was given back to her. Our time starts counting again. So that means 30 days minus 14 that she has already used. That means after she gets the TV back from the repairer, she has how many more days before she can exercise the initial right to reject? She's used 14 before out of 30. How many more days has she got left? 16. Good. Thank you very much, Lord Chi. Very good. So she's got 15 days left to reject after the repair. But if the repair has not been effective and afterwards the TV is still bad, she's only able to accept one repair. She doesn't have to accept further repairs. So Christine could ask for a further repair, but that's up to her. She's not first. Price reduction, good. Yeah. So you all get this. So in summary, you might also have to look at section 24, 23, 3 of the CRA on um there's a defense to what she or claim if they have a claim, but the law really protects the consumer. So looking at section 24(5) as well, she doesn't need to accept any further replacement or repair before exercising a final right to reject or price reduction like Law Chi has written there. So she could move to the second tier and exercise a final right to reject. If this is carried out in the first 6 months, the goods are not a motor vehicle, she's entitled to get all her money back. She's in that position, she can get all her money back. Um, we there's that point as well talking about what I said, underline the points you see hanging out in the question. There was something about the delivery note, isn't there, saying that the goods were delivered in good condition and they've complied with all the law. While this appears that Christine has waived her right, no, she hasn't, because pursuant to Section 31, to exempt liability as against a consumer for breach of contract is not possible. So a consumer again has a higher level of protection. So the waiver on the delivery note has no effect. So now this is when you want to round up your discussion. In conclusion, the same goods seem to be defective and in breach of the requirements of quality and fitness of purpose. So what does that mean? Christine is able to exercise her right to reject the first one, 30 days, or ask for a further replacement or repair. And she can also exercise the final right to reject and get a full refund, get a full refund. So that's it for Christine. We can see how we've answered that question now. I don't know if you've got questions before we move on to talk about SGSA. Is there anyone here that likes SGSA? Because if I were a student, it would be my one of my favorite question yeah topic because it seems straightforward, doesn't it? Yeah. So the question is, does mitigation of loss apply to consumers when it comes to the remedy discussion? Uh, Mitigation of loss. I mean, it's not very clear. Have you got any authority on this? On mitigation of loss? Yeah. Would quality and description be a problem? Question. Pray, 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 Twain. What does that authority say? What does it say about that? Because that's not one of the things we're examining you on, and I don't want to go into. Yeah, I mean, if you want to discuss it by all means, but in this case, what would that look like? Has she done anything that would mean she has worsened our situation? When we're talking about the SGSA, we would see that the consumer needs to act fast or needs to be careful not to alter their position. Right. So the protection offered to the consumer, while it's very great, doesn't mean consumers will not take a hit if they sleep on their right or not. Okay. Someone's asking if quality and description, it's a problem question. It's always been a problem question. Yeah, that's a very good way to examine it. It's making it a problem questions just help you apply your understanding of the law to the fact. So it's a problem question. And you notice that in the two questions we treated, both are problem questions. There's one on B2C and there's one on B2B. So I want us to get started on um, SGSA. I don't know why it's starting on that slide. Supply of goods and services. Let's see. And SGSA is essay above. So SGSA is also problem question. It's a problem question. Yep. So let's quickly talk through the slides and hope we oh, let's see. Let's see what we do. Let's see. So this we've talked about different types of contracts, and some students may get confused about if the question they're looking at is the SGA contract or what's it called? Is it an SGA contract or a sale of goods contract? What you want to think about is what is the substance of the contract. Say if you ask someone to sell you goods, a bottle of Coke, a kind of malt, a kind of energy drink, that is a contract of sale of goods. Well, if you're asking someone to buy new sinks for installation in your bathroom, we want to know, are they also going to be installing the sink? If that's the answer, then it is supply of goods and services contract in the sense that you're not buying the sink just to stay at it. Skill and experience, yes, those are the things you would expect when it comes to it's very easy. You would see that in the question there is some service required of them in relation to installation of something or making of something. So these are some authorities on that, on whether what the substance of the contract is. So in B2B or B2C contract, if you're faced with a question, remember we said that there's a structure you need to follow. You can write it in any way, but these are some of the things that help you put your thoughts together. The first question is it a B2B contract or a B2C contract? And this question is to enable you identify which law applies. So if it's a B2B contract, then you would be applying the SGSA 1982. If it's a business to consumer contract that was entered into after 2015, October 1st, 2015, then that is a CRA contracts. You need to apply the Consumer Rights Act. So other contracts between consumers and a, uh, a trader, a business, before 2015, those were covered by the SGSA, but this has changed because remember, the CRA now gives the consumer more rights. So types of contract, we've talked about that, non-sale of goods contracts, barter. There's no money consideration with barter or exchange, so it's not even a sale of goods contract. And there's also um, a mixture of labor and skill, like one of you said rightly, as well as like some of you said rightly, as well as goods. So you're getting a mixture of both. Then the SGSA applies. If it's a B2B, if it's a B2C, the CRA applies. So sections 6 to 10 apply to hire contracts, which is different from hire purchase. We're going to touch on that when we're talking about NEMO-DAT. So SGSA Part 2 covers the services. If you're given a question, you might have to talk about sections 3, 4, and 5 when um, when you're talking about the goods, and then you move on to talk about sections 9, etc., when you're talking about the services in question, which is under Part B of Part 2 of the SGSA. Again, I've said the CRA applies to consumer contracts, so that's a straightforward one when you're answering the question. Now, if you're answering a question on SGSA, there are three main things you need to talk about. The first one is, was the service or work done badly? Are faulty goods supplied? So in determining the supplier will still be liable for both, but you just want to know where's the liability? Is it for the goods supplied or is it for their work? But because they're the one sourcing the materials, they'll still be liable. The next thing to talk about is the time. Was there a stipulation as to the time of the contract? If there was, has this stipulation been breached? If there is no stipulation, we're thinking about a reasonable period of time. Did it take them too long from what a reasonable person would expect? So again, we're looking at that elevated person in law, a reasonable person, a reasonable person. And the final point will be about the cost. How much was charged? Does it deviate from the agreement? Was there an agreement really about the cost? If there is none, we might have to consult an expert and then we'll rely on what a reasonable pay cost for this kind of contract would be. So there's some examples here. You've taken your computer to upgrade the CD player to a DVD player and it will not work well. So that's one example. This is another one. Nick buys a new sink and tap and asked a plumber to fix it. And after installation, it was discovered that the tap drips for a while afterwards. And the issue here is excuse me, because Nick buys the tap himself, there's that higher level of responsibility on him to prove that it's the fault of Nick. Uh, no, it is the fault of the plumber, rather, not because Nick buys. So what is really advisable is the products should also be procured by the installer, by the uh, trader, by the plumber, by the trades. So let's look at the provisions of the Act. When it comes to passing of title, Section 12 of the SGA, Section 2 of the SGSA, description, remember we've talked about that, satisfactory quality and fitness of purpose. Also, all of those are covered by Part 1 of the SGSA. And then the Part 2 covers the standard of work, the time it took, and the cost, the price. And we're going to see the distinction between estimates and quotes. So we want to know the one that will bind the contractors. So starting with section 2, this talks about the transfer of property. we can be likened to our section 12 of the SGA. There's an implied condition that it has a right to transfer property. And this is often not problematic. It's often not part of the things we examine because no one's gonna come and say, yeah, this sink is stolen. I mean, it could happen, but it's not one of the things that I've noticed that I've seen in our questions in recent times. So you may not want to. Do we need to cover part one? You're going to see that you need to talk about faulty goods. So you're not necessarily covering this condition, the condition on title, not necessarily, not necessarily. But you will be required, if you've done it well, to cover this, section 3. Because it could be that what was supplied was different from what was given to you. And I think this could manifest in the form of you asking them to use top end tiles to fix your bathroom. And you've paid them to do this. But what have they done? They've gone to buy the cheaper ones, which are not as good. So yeah, you might be required to do this, but the one that you definitely will not be able to escape will be section 4. But let's look at this first. So this provides that where there's a contract to transfer goods, there is a condition that there's an implied term that the goods will correspond to that description. Yeah, absolutely came because he bought the goods himself. So that is covered. It might have a claim against the person, the seller, which is separate from yeah, very well. But if he has asked the plumber to fix to replace the sink in his bathroom and the tap, and he has got nothing to do with it, then it's the plumber that will be liable. But the plumber could be liable for this under section 3 if the claim is that the goods bought are not what they've agreed on in the contract, the goods installed are not what they've agreed on in the contract. So you see, section 3, the equivalent of that in the CRA is section 11. In pari materials, very much similar. But this one is a big one. Implied terms about quality, because when we're talking about the leaking tap, it could be that the quality of the tap is defective and that's what's making it leak. So what we often see in the questions is that it's not clear, it's often not clear whether the products do not do well, this tap is leaking because this is due to defective product or this is due to poor installation. So you will do well to apply both. Start by saying it's not clear whether it's the installation that is effective or the products are faulty. And start by saying if the products are found to be faulty, section 4 provides that there's an implied condition that the goods are supplied under the contract are of satisfactory quality. Move on to talk about section 2A, 42A, what it means for goods to be satisfactory quality. But you remember, looking at the provisions, that the distinction is not, there's no distinction between the provisions of this section and the section of the SGA. So you can apply all the authorities, all the cases on that to this. And the equivalent provision for that under the CRA is section 9. Now, talking about satisfactory quality, again, this is the provision of section 14(2) of the SGA. Yeah, so the cases are what? Relevant. Now, still on that section, what common law cases apply? The same common law cases that we've applied in talking about satisfactory quality. We've talked about Christopher. There's Christopher's case. There's Valley versus Weep, and a host of others. Law, uh, Law Chi. Can you? Yeah. So those are the cases. I'm trying to remember now. same as SG. Yes, that's what I'm saying. So Valley versus Weep. There's the Attenborough case. There are lots of them. New last season. Yeah, that's about identity. And there are the other cases about what's it called? About satisfactory quality as well. So all those cases, yeah. You don't have to. You don't have to repeat all of it. Just make sure you're summarizing it. You know why you don't have to? Because you've got 3 hours to answer three questions and you might not have the time to do that. So make sure you're able to cover the rest of, because this is not the, is one of the main things you need to discuss, but you need to dedicate more attention to uh, the skill and the installation itself. So make sure your discussion here is succinct, is short, is concise, and then move on. So this is not an opportunity for you to regurgitate everything you know about sections 14 and sections 13. Yeah, I hope that clarifies it. So we just wanted to be sure, we just wanted to get this out of the way and show that it goes back to this question that I'm not able to answer. I've answered the question that I think will really help you. And because the authorities are similar, and the only thing that is different is the higher level of protection offered to the consumer, it's an open book exam. You're using the same statute book. So I think it's okay for you to understand both and then be able to determine that. You know what's going to happen if I tell you whether it's a B2B or B2C contract? I'm answering the question for you, and that's not what this session is for. These sessions are for you to ground your knowledge, to ground your understanding in the law on all of that, and then be able to answer these questions in a confident manner. So those are some of the things being tested. Now, still talking about sections SGA sections 4, 5. If the purpose has been made known, and we're going to see this play out in one of the questions we will be answering. If the purpose has been made known to the trade, then they have to ensure that it's being done to that specification. So you see, so far, similar provisions for the SGSA and SGA on the goods. Now we can talk about liability. Exempting liability for terms. These has to be tested against the Unfair Contract Terms Act. If it's unfair, it will be struck out. If it's fair, it will be made, if it satisfies the requirements of reasonableness. But when it comes to consumers, again, higher level of protection. You cannot exempt liability for description, quality, fitness for purposes, as well as section 2, ownership, being having the right to transfer title. You still will be unable to exempt liability for that. Now, moving to where the main discussion will be. If you don't do the section 3 and 4, uh, you're going to lose points. But if you don't do the rest of it, you're going to lose more points. So don't forget to apply sections 3 and 4. Those are very relevant. But this is where your main discussions should come from. So, three main sections on scale and scale, on time, as well as price. So, section 13 relates to the services to be performed with reasonable care and skill. When no time is fixed, it has to be carried out within a reasonable time. And if there's no price fixed, it has to be done, a reasonable charge will be paid. Now let's look at the sections. In a contract for the supply of goods and services, and this person is acting in a course of business, they must carry out their service with reasonable care. And because this is an innominate term, it does not automatically lead to repudiation or damages. We will look at the implication of breach on the claimant, and then that's when we'll be able to determine whether there's been a breach of a condition or the breach of a warranty. In business to consumer transactions, section 49, 50 says that, and 50 says that you need to exercise reasonable care and skill. And also, going by section 50, you need to let the consumer know what you're doing, provide them with that detailed information about the trader and the service you're delivering. And that's just to avoid arguments or stories that touch it later on. So let's break it down. Standard of care. You must exercise reasonable care and skill of now we go back to that reasonable person, a reasonable, competent member of that profession. So, what would an average member of that profession that is reasonable, what would it look like? And in interpreting this, medical cases in negligence claim are being applied. And we got a case of Bolam on this. Bolam tells us what reasonability is as one of the elements of negligence. So these are some of the points that are relevant. In a specialist field, you're still expected to have the skill or demonstrate the skill of a reasonable specialist in that field, and you cannot guarantee a specific outcome generally in general terms, but you may be able to pay more as a consumer or as a buyer, as a trade person using this to get a guaranteed outcome. But that's not the general expectation. The general expectation is that the person will do their best to serve you. So someone new to a field is judged by the same standard of an ordinary person. In this case, I think a learner driver was held to the same standard as a licensed driver because the court does not care about you being substandard. So if you've got apprentices, if you've got junior members of the profession, they would still be held to that average, the standard of a reasonable, competent person in that field. So it's not a defense to say, oh, it was my apprentice that did it, it was my student that did it. That's not a defense that you can use. So, like I said earlier, you cannot guarantee a particular result. In this case, Fake versus Morris, it was about fertility clinic where yeah, the person still got pregnant, they were fertile, and the court said, yeah, you cannot guarantee an outcome. And I want us to think about this case because it is one of the cases we examined, the Fake and Morris case. It's one of the cases we examined under negligence. And in talking about the elements of negligence, public policy is one of the key considerations. So I think this authority should should be treated with caution. I mean, it says you don't usually guarantee a particular result or outcome, but if you've asked someone to build you a chair, you should be able to sit on the chair. You should be able to use the chair. You should be able to use the table. You can't say, "Oh, we did not guarantee a specific result," and this is what you get. And the kind of background, we don't have time for this, but I'll say it anyway. The kind of background we have with Fake and Morris is it's set in where health service is being produced by government, and lots of cases, negligence cases are like that. You know, when it concerns the NHS, you don't want to make government liable to people for mistakes made by medical practitioners because it's the public that is bearing this cost. So yeah, you don't usually guarantee a particular result or outcome, but there's still something you would expect. And there's a development expansion on that principle here that it is possible for the parties to contractually guarantee success or an outcome, but that would come at a premium. You need to negotiate that specifically and pay the cost of that. For services not in compliance, these are some of the remedies. And please talk about remedies. Don't just say there's been a breach, there's been no breach, full stop. What are the remedies? Repair or repeat performance. So you can ask them to come and repair what they fix, or you can ask them to reduce price up to the total amount of money paid. So there's no limit. I mean that's the limit, but you can recover all the cost you've paid. Talking about installation in B2C contracts, again, similar content of the provision, according to Section 15 of the CRA, they have to install it correctly. And this is strict liability. So they cannot say it wasn't due to my fault, it was my apprentice, it was my this, and you cannot exempt liability for it. Remember, when it comes to B2B, you can exempt liability provided it complies with the concept of reasonableness under the OCTA. But for consumers, you cannot. So this is the main distinction, and these are the minor points you need to note to be able to answer whichever questions face you. And even if you're answering a B2B question, you can say, yeah, for consumers, this is not the position. And that just shows you're able to, yeah, you cannot guarantee an outcome. Okay, I'll go back to that. So what it means is that we know in contracts, you would like to know what the outcome would be. But the law, going by this case, Take and Morris, is that even though you've entered into a contract to do something, no one knows what the outcome can be. So it is not possible, it is not the usual expectation that that outcome is guaranteed. And I want us to interpret this case, this um, principle in relation to the authority, the Thake and Morris case. So I think one person went to the fertility clinic and said they want to undergo a procedure that would mean they're not going to be able to have children. And that was done. So I'm trying to see what comment is there. Yeah, so no guarantee to get a baby boy, a baby girl, whatsoever. So, and they actually became fertile and someone got pregnant. So they sued. And you would think if I'm going to a clinic to say I don't want to have any more children, you should be able to tell me that. But the court in this case said you cannot guarantee that outcome. And I struggle to agree with this, but it's the law, isn't it? So you want to state it there that you cannot guarantee an outcome. Ding. You cannot guarantee an outcome. That's what it's saying. Generally, usually. So if you're paying for the normal contract, you may not be able to guarantee that you get a baby boy or that you will not be able to have any more children or that you're that's why I said, Lee, that it's one of the cases when you're looking at the NHS. There are so many cases out there that you're under negligence that you're thinking, no, that's not right. But it's because it's funded by the public. NHS is going down. Yeah, you get it. We don't want to go into that. But that's the law. So you can just mention that and say you cannot guarantee a particular outcome. But it is possible for the parties to agree and say, this is the outcome I want. Give me a cost estimate that gives me that outcome. So what it's saying there, I know it's confusing, Ding, is that ordinarily, you know, when you're buying ice cream, you've got the vanilla, which is a normal ice cream. Anyone, the normal one. And then you can say, I want chalk ice cream, I want strawberry. So the vanilla, the ordinary contract you're having does not guarantee an outcome. But if that outcome is important to you, you have to state that and contract based on that. Just like the way you're saying, I want a chocolate topping on my ice cream. Does that answer your question, Ding? Do you understand? Okay, good. If you don't, just drop me an email. I've got an email I need to respond to. I know that, but I can break it down again. So that's it. The vanilla, the plain contract does not usually guarantee a particular result or outcome. But if you want more, you need to contract and guarantee that, like, yeah, I don't want vanilla ice cream. I want a topping on it. And that way you guarantee an outcome. So where were we? I think we've gone. Where? Let's go back. Yes, I was talking about it. So there's strict liability. You don't have to show it's no defense that it's not my fault. It was my apprentice, and you cannot exempt liability for that. I think I've said that. So moving on. In terms of time, so all we've said there, talking about the level of expertise, talking about a- apprentice will be held to the same level as the what's it called as an exp as an average practitioner, a qualified practitioner. The next thing to move on to is section 14, which talks about time. So generally, you want to look at the contract, what was said when the contract was being agreed. Was time of the essence? Because generally, that's not the case. You have to agree and say, time is important to me. So you want to ask, in this contract, is there any representation made? Is there any statement relating to time is of the essence? We want this to be done on time. And the authority for you to understand what that is the United Scientific Holdings. But if you've not said anything in the contract about this, Section 14 SGSA has got your back. It says that when under a contract, the time for the service is and the time is not fixed by the contract. It is left to be fixed in a manner agreed by the contract or determined by the course of dealing. So again, we're going back to that reasonableness. What would a reasonable person expect? And what is a reasonable time is a question of fact. Similar provision to that in the CRA is section 52. You can go back to the United Scientific Authority to apply because the provisions are similar. So now how do we determine when the parties must perform? In the authority above, the court, which LJ Wynne said, reasonable time will depend on the circumstances that exist. And it says, yeah, if that delay is being caused by the trades, then you cannot say that's done within reasonable time. So if you've contracted for someone to do your bathroom and they leave everything to their apprentice, that could be a delay being caused by them, and they cannot be able to rely on that. And we're seeing the cases, Rickards and Oppenheim that we talked about yesterday. So that's one for two. You can use this case here and then also use it in relation to sections 13 and 14. So that's one. So when must the parties perform? Those are some of the considerations. The contract should set out the price. So we talked about time, reasonable time, and I'm going to answer two questions on this. We're going to see how this plays out. What I'm trying to do now is to just give us that primer on what the law is before we get into applying the law application to the fact. So the third thing will be the issue of price. Take versus Morris, Samuels and Davies. I can't say I remember what Samuel and Davies is about now. If you want to shed more light on that, yeah, I can talk about it here. So the contract should set out the price. And more often than not, in our scenario, we'll see that that's often not the case. You can have estimates, you can have quotes, but the court are often faced with this question. So we would expect normally that the parties to the contract agree the price, but that's not always the case. That is not always the case. So if no price is stated, Section 15 of the SGSA has got you covered. So under a contract for the supply of goods and the consideration has not been agreed, this needs to be determined by what a reasonable supplier will receive. How much will a reasonable supplier receive? And that goes again back to the question of reasonableness. So we're looking at a lot of reasonableness here. Similar provision in CRA section 51. Now we've seen that attempt to distinguish between estimates and quotes. People have said quotes means binding, estimate means not binding. But we see that the court does not really care about the term being used. What really matters is how the parties behaved, how what everything that was said. So there are three cases there. We're going to apply these in the answers. So hold on to that thought. Now, in terms of exclusion of liability, if it's being examined, those are covered. If it's a B to B contract, those are covered by sections 2 and 3 of the ACTA. You cannot exclude liability for death or personal injury. For other laws, it has to be reasonable. You're just not able to get free from your liability. You cannot extra protection for consumers, so you cannot fully exempt liability for breach under CRA. You cannot. It's possible to exempt liability to the limit of the price paid and say we will not be um, liable for more than the contract price paid, but this could be challenged if it seemed to be unfair. Okay, so we're done with that. Let's see what time it is. Looks like I want to look at my plan for stop share. I want to look at my plan for today and see how we're doing. So answer, we've done that. SGSA. So now let's crack on and talk about the questions under the SGSA. And you see some of the things you need to do to have a good, no, excellent, very good result. So trying to questions, share. So now I'll give us a moment to read this. Or have you read it already? We should just get on to answering it. Have you read it? Should we just we'll be going on break in 30 minutes time. So do you need time to read this? You're not responding, so I'll give you time to read it. So we see the word an estimate was used there, an estimate of 3,000, and said it will be a straightforward job. So she accepts the estimate. So what is your starting point? What will you be starting with here? Okay, let's see. Contract type, good. B2B or B2C? Contract type, I think the first thing you want to determine is this a contract of sale or a contract of goods and services? And then you want to ask, is it a B2B or a B2C? So someone is saying it's B2C. Why do you think it's a B2C? Why? Why do you think it's a B2C? Out of business, yes. She's contracting out of her business. It doesn't even say if she has a business or not. So we're assuming she's just contracting out of her business. Now, we don't know what was really said. If John made any representation, he just said it should be a straightforward job. So that would talk about the technicality. It's straightforward. But it doesn't seem like he has guaranteed any type of outcome, right? So We've determined the legislation, have we? What legislation is relevant here? Have we determined the legislation? Have we? Good, very good. SGSA, no. CRA is the CRA because um she's contracting as a consumer. So it's the CRA that applies, right? What are the sections we'll be looking at? Section 2, in terms of right. I'd advise not to waste time on section 2 because I don't think that's an issue. If that's a fact an issue, you would see something along the lines of someone is contacting Christine, asking her to return the things that were installed. So it's not an issue, Kim. So what we want to try to avoid is to go off on a tangent, talk about things that we know that is not being examined. And that's the beauty of a problem question. You can focus your attention on the things that really matter. Right. So section 2 might be something that we think about, but in this question, is there any fact talking about, yeah. So the sections that are relevant are sections 3, sections 4, section 9, 11, 10, and then we can talk about the damages, the remedies, and all that. Yeah. So let's crack on. Under section 11, starting with section 11 of the CRA. Oh, it's not section 3 and 4, that's of the SGSA, so I'm mixing it up myself. Under section 11, what does section 11 say of the CRA? So not section 3, not section 4. That would be relevant if we're talking about um, B2B contract. So these mistakes are very easy to make. Description, yes. To make it clearer for yourself and avoid getting confused, like, yeah, what you want to do is to write out the main things in a separate note and say, so there's description, there's fitness for purpose and quality, there's the issue of time, there's the issue of performance, and there's also the issue of price. And then you want to open the relevant statute because you've got the statute between the assessment. You want to open it and then use that to answer your questions. So let's start with section 11. What does section 11 say? Now we have to read the provisions of the act. And for that, section 11 provides that the goods must match the description provided. Now we want to understand, what did John describe? What was the description he made to Christine at the time of the contract? And that is what will determine whether this is covered. This is the contract. Those are the terms of the contract. So we need to know that. And we also want to point out that this contract, because it's a consumer contract, will fall under the Consumer Contracts Information Cancellation and Additional Charges Regulation because this is an on or off premise or distance contract. Special bathrooms should have provided information of the main characteristics of the contract, the agreement, the cost, the time for performance, and these will form the terms of that agreement. So did it provide that? That's not clear. Maybe they breached a statutory provision. But if they have, that will of course form the terms of the contract. So now let's start with section 9, which provides that there's an implied condition that the goods must be of satisfactory quality. Remember, this is a strict liability provision. So if the breach uh, is if there is a breach, there will be liability, notwithstanding that it wasn't due to any fault on the part of John or his business. So that's section 9.1. We can also look at section 9.2 that provides that goods are of satisfactory quality if they meet the standard that a reasonable person would regard as satisfactory, taking into account all those factors, the price paid, the description, all the relevant circumstances, including the freedom from minor defects, fitness for purpose, um, for which these goods are commonly supplied. So there's also the issue of durability, safety, appearance, and finish, all of that. So those are things we need to investigate further. Um, the nature of the discussion they had and what that would um, trigger, what that would make a reasonable person think of. Other circumstances by the CRA, Section 9(5) specifically, include anything stated by the trader, producer, or agent in public statements. So was there a brochure? Was there a website she went to? Actually, she went to a website. So are there anything there that we can argue that she relied on to get this contract? Other circumstances um, could include all of those conditions we've thought about, the durability, etc., etc. So we need to understand this is a special type of contract in the sense that she's trying to fix the bathroom for a disabled person. So we will assess that service in line with the standards of a disabled bathroom. That's what she wants. But do we think she told him that? Did she say this is the bathroom for my mom that is disabled? And the reason we want to know that is because if she didn't mention that, there are some tiles that may be good for normal people walking on foot that may not be great for wheelchair because they tend to be clunky and metals and all that. So did she make that representation? Because if she did, and she relies on his um, view, on his promise on that, then he will be liable. But in this case, the bath leaks, um, which that shouldn't happen. The bath shouldn't leak. So this indicates that there has been a defective installation or the product John uses is not satisfactory. We also know in this scenario that John told Karen that she would need new tiles to be installed. But after installing these tiles, we saw here that they are slippery. That's what she's saying. The tiles are also very slippery, and three of them have broken without any apparent reason. So we can see that those defects give rise to questions of safety. If it's not safe, you know, when tiles break, you can trip on them and cut yourself. So if these are not safe, can we argue that that's of satisfactory quality? And again, the authority on that is Bernstein, that is already in the chart. Bernstein and Palm Motors. And there's also Lee and Yacht Coach and Marine. So these are, if something is not safe, by now we should all know that those authorities, because we've mentioned them earlier. Now, it is also key, it's crucial to think about if the goods are fit for all purposes for which goods of that nature are commonly supplied. And that would require us to think about if this is to be used, if this is to be measured as a general bathroom standard or by a general bathroom standard or those for a disabled person. Do you think general bathroom standards, do you think the tiles would have broken up and yeah, or with the bath leak? So people can argue that in today's age, I think we've got some rights on the rights of disabled persons. So whatever we're doing, whatever everyone's doing, should consider how disabled persons are affected, right? So is that the case here? Arguably, people would say all bathrooms should, yeah, accommodate all persons, and it needs to be fit for every. Oh, but it does not need to be fit for every conceivable um conceivable reason. So we're not raising an onerous condition here. We're not. What we're asking for is something that is good enough, but we're not expecting perfection. So the authority I've popped in the chat is the one that says that it doesn't have to be fit. The product doesn't have to be fit for all conceivable purpose. That would be too onerous a condition to hold value. It's just too onerous. But we expect some level of quality in things of this nature. Remember that the price paid is also a factor that will help shape our expectations. Going by the authority of Rogers and Parrish, price is a key factor. But the stated effects appear to be so basic. We're not saying drink Coca-Cola and rule the world, like the example you made yesterday. We're not saying make the bathroom and fly to Hong Kong from Manchester. That's not what we're expecting. We're just expecting someone to be able to enter the bathroom, use it without having any mishap. And that has not been met. So price doesn't weigh in here heavily here. No matter what the price, that's the basic. So the leak, in this case, that leak may suggest that the goods are not free from minor defects. Even if a leak could be remedied, could be corrected instantaneously, that still does not mean that it meets the condition of the expectations of a reasonable person. So we might apply the authority of EGAN, and Motor Services on that. In this case, not in EGAN, still the argument here is that the defects may indicate that they are not of satisfactory quality because they're just not strong enough, they're not durable to for this purpose. So that's the main thing we're hanging on. We're thinking the tiles are defective, right? And if the court determines that these are not defective, then we want to go on and argue that they may be improperly installed. So whichever way, he is still liable because he's the one that got the tiles. So we will need to send a bathroom expert to view the property and report on the cause of the defect as to whether it's the faulty goods or they are badly installed. And I think this argument would also be relevant if the tiles were bought by Christine and she has instructed him to install it. You might need an expert to really determine if it was a good, in which there will be a claim against the supplier of the goods, still under the CRA because she's a consumer, isn't she? And if the expert says it's due to installation, then she might want to go on and apply the sections on expertise and skill, etc. So now we're moving on now to talk about what you would expect, what a reasonable person would expect. So pursuant to section 10, subsection 3, we have an implied term that the goods must be reasonably fit for any specific purpose brought to the attention of the transferor when they are supplied in the course of business. So what is not clear is whether this was made clear to the person that a mother is disabled. So I was saying Christine is carrying, isn't it? So we want to know whether our mother, she made known to him that the mother is disabled. If she did, then we would expect that special bathroom because he would have made some representations to her that we will make this in line with what your mother requires. So this is a question about Christine, Karen. I keep saying Christine. I don't know why. Maybe it's because of the first question we answered is about Christine. So did she make any representation to any statement to him along the lines of this is for a specific purpose, and did he agree to do something that would be to help with that purpose? If the special bathroom is one of the intended is one of the intended for a disabled user, then we might expect that all elements of that bathroom will be suitable for a disabled person. So we cannot we cannot say it's because of the wheelchair or the hoist machines or all the other things used. An example of this is where the tiles broken because the wheelchair was used. in the bathroom, or those hoists or lifting equipment were used? Or did Karen make it clear that her mother used any of such equipment? And she also complained that it was sleepy, the tiles were sleepy. That doesn't matter whether you're disabled or not. You expect the grip of a bathroom tile to be firm, so it shouldn't be sleeping or slippery or whatever. In this case, we would argue that the goods are not reasonably fit for the purpose of a disabled part bathroom. Even with the sleepy part, it's not even fit for the use of a non-disabled person. So we would argue that yes, there's been a breach here, but the determining factor under section, so there could be a breach under section 10.2 or the other sections. But for section 10.3, there has to be that agreement, that extra agreement that this is for a disabled person. We would want to know if John made any promises in relation to the level of expertise to be expected, and if Karen relied on that expertise in the selection and suitability of the materials. So, or did Karen, did she choose the tiles herself? Did she choose the tiles herself? If she did, then we would argue that she actually did not rely on John's expertise. The authority on that distinction is camel lead and manganese bronze. So I'll just spell the first one, Cammelled. So that case, that's the one on the distinction. Yeah, versus manganese bronze. So I want to ask whether the tiles have been used made for the floor. You know, there are some tiles that you use on the wall that can be slippery, but if it's on the ground, on the floor, it has to be firm. So we have to be clear about that. If they're not, they may not be weight bearing tiles. They may not be tiles you can stand on, which is why they've broken. So those are some of the considerations we might want to consider. And if the argument is that these defects are because they've not been installed properly, that's when we move on to talk about section 15 or 49 of the CRA. So there are two ways to challenge installation under CRA 2015. Section 29 is parallel to the implied term under section 13 SGA. It is parallel to that. While CRA 15 improves significantly on the pre-CRA, before CRA, we said now we have more protection for buyers. So it's an improvement on the previous position. Where the goods are supplied include their installation and the goods does not conform to the contract unless they are installed correctly, this bridge carries strict liability, so it doesn't matter that there's no fault. And it's also not possible to exclude that provision going by Section 31 of the CRA. You can limit the implication, but you cannot exclude it. You can limit the cost that will be incurred by the trades, but you cannot exclude that liability. So Karen, in this case, needs to show that the goods have been installed incorrectly if she's going under Section 49, 50-ish. It's not clear in this situation what standard will be applied to determine the meaning correctly. We know that there's the ordinary standard that you would expect of someone in that profession. So that's the first one. But we're saying something in relation to specialists here. So is that what we want to rely on or not? But even at that, it is clear that the range of defects show that they've not been done averagely well. So we have cracked tiles, leaking bathrooms. These will not be considered to have been performed correctly. So if there is a breach of implied term under Section 15, that consumer has the right to to request a repair or replacement of the goods. And if these goods do not conform, then the right to a price rejection or the final right to reject the goods can be exercised. So it's again tiered. You can reject, repair rather, or request a replacement, or you can reject it later. Now, under section 49 CRA, when a trader carries out a service that is an implied term, that they have to exercise that reasonable care and skill. Also, Section 50 says if they have given information about what they're going to do, then those terms form the terms of the contract. So if they tell them how the work will be performed, what to expect, that's the term of the contract, and they will be bound by that. Now, we can ask, what is meant by reasonable care and skill? What does that mean? Because it looks like a vague term, reasonable care and skill. That would really be difficult to determine. But the explanatory notes to the CRA make it clear that the standard is the same as the standard under Section 13. So we will need to consider the common law. What does the common law say about this? What are the cases decided on this? So, breach of this term leads only to negligence liability. So, there will be no liability unless there is fault. Remember that for negligence, there has to be a duty of care, a breach of that duty, damages arising as a result of that. So, it's a negligence liability. You are required to meet the standards of a reasonable, competent member of that trade, and for that, we have the authority of Bolam, some of the medical cases I talked about earlier. In this situation, as a bathroom fitter, there's no defense to say that you are inexperienced. He's not inexperienced, but I think he had his apprentices to do the job. So he cannot come to claim that it's because they are inexperienced. That's why it wasn't done well, and that would absolve him of liability. No, it will still be liable because remember the case of Nettle Sheep and Weston, there's the principle that inexperienced members of a trade or profession will be held to the same standard as a reasonable person in that profession. So where where yeah, where you do where what you've done is what a reasonable competent person would have done, you would not be negligent. But another way, one of the ways to test that is to show that a responsible body of opinion, going by Bulem, that's what they would have done. But I think that doesn't seem like it. If you've asked someone to install your bathroom for you, you would expect the tiles not to break. So close to the completion of the contract, you would expect the bathroom not to leak rather. So yeah, that doesn't seem to be the case here. I think someone has been negligent and they just need to be liable for what they did. So the degree of expertise is a facting issue here, um, because it says it's a specialist bathroom installer. That's what it says on the facts. Looking at the facts here, let me minimize this. So it says special bathroom limited. So it's, yeah, that's been said there. But at the same time, would you say that is a determining factor? Aside from that, would we also expect a higher standard because it's a disabled bathroom? The law is the principle there is the degree of expertise that supplier claims will be relevant to what is expected of them. So, what representations have been made in this case? What were the representations made? So, for that, we've got the case of Phillips and William Whiteley. So, what have they said? They will be held to that standard of what they've said. We want to think about what did John say about his business? Did he say he was a specialist? I mean, he did say he's special, but does that mean he's a specialist? And they should meet the standard of a reasonably confident person, specialist fitter. We also got a case of Greaves and Boehner, where a specialist consultant was only to be judged as against the standard of an ordinary competent. So So one of you asked me a question earlier about if you need to cite the fact of a case, and you see what I've done here in Greaves and Bain, Bainham. In that case, an engineer, a specialist consultant engineer was only to be judged as against the standard of an ordinary competent consultant engineer practicing in that field and not as a top provider. Yeah, agrees. Yeah. So you can see in this case, the fact is relevant, and we have not gone into too much detail on it. Now I have to round up quickly before we go and break. So that's relevant. The requirement is to provide a reasonable standard. Will not guarantee results. We've talked about that. We talked about the takes and Morris, and there's also another case here, platform funding and Bank of Scotland. It just means that person will exercise reasonable care and skill. So that doesn't mean they've guaranteed a result. So you can have a look at the case I just mentioned in addition to the one we talked about in terms of the so platform funding versus Bank of Scotland of S. You can have a look at that in addition to the authority. So that doesn't mean you cannot guarantee a specific outcome, but if you want to negotiate that as an extra, you can do that. So John will not be able to point to any relative inexperience of his employees, and we also may not be expected to treat him as that specialist except that's what they've contracted for. So the fact that the bat leaks would be clear evidence that it has not been done well, and in addition the tiles are cracked. You want to ask, is it because the tiles are defective or because the tiles are not installed properly? Whichever way, this is John's breach because it's the one that supplied the it was is the one that procured the tiles. So for the breach of implied term under section 49, you can ask for repeat performance or you can ask for a price reduction. So Karen could ask for either of that, but this has to be done within a reasonable time. This correction has to be done within a reasonable period of time and without cost to the customer. If the work is not carried out well at that point, then she can get a full, she can ask for a price reduction up to a full amount of the contract. In the guidance notes to this CRA, there's a suggestion that the price reduction will be the difference between the value of what was provided and the contract price. That's what we call the principle of quantum merit, possibly. So a full reduction will be appropriate if she has been deprived of all the benefits of the contract and she needs to get a new supplier that would have to start from scratch. So Karen in this case is entitled to pursue non-statutory remedies. She may be able to sue for damages, etc. Uh, in addition to, instead, or in addition to. Yeah, yes, that's the spelling, quantum merit. So you can get that in the guidance note to the CRA. So she's entitled to get that. And if there's any issue caused by the leak to the flooring of the house to make the house inhabitable, she may be able to claim that. But I don't think there's been a an exemption clause here. If there is, it has to, you can't exclude liability for some things against a consumer. So you might also want to have a look at section 54(7), where there's been more issues caused by the leak. If the trader has breached a term that has not affected performance, maybe the status of his workers, then it may be possible to claim a a breach of price reduction. So they've done something, but it has not. They have breached a term that has not affected performance. Yeah, we can still claim a price reduction. The contract is likely to fall within the scope of CCIC, yeah, CCICAC regs, that 2013 regulation. So you ought to have provided her with some documentation in relation to what was being supplied. If it did, that would form a part of the contract. Now, talking about the estimate he gave to, um, when he was talking about the estimate, he said it will be a straightforward job. And in relation to the issue of time, we don't think they've agreed to any specific period of time in this case. So if time was made an essence of the contract, which is unlikely in this case, we don't think it's likely. There's the authority of United Scientific Holdings and Burnley Council. In that case, there was no time specified in the contract. And pursuant to CRA, where there's no time specified, we can rely on the CRA. We expect it to be carried out within a reasonable period of time. We can look at sections 52 on that. Subsections 2 and 3 are speak to what a reasonable time will be. So, what was discussed between Karen and John at the time of fitting? Was it made clear that the work has to be completed? We don't know what they talked about. And we've got some authorities on that. There's Charnock, Liverpool, Charnock, and Liverpool. So on that, in that case, the claimant took the car to the garage for repair. And normally, this should have taken the garage 5 weeks, but because they had staff shortage and all that, it took them 8 weeks. And the claimant sued for, breach of contract in relation to time. And the court said 8 weeks was unreasonably long in that circumstance because these are some of the things they should have taken into consideration. You would expect that there will be some itches here and there, so you should have factored that into the contract when you're making the estimate. So in this case, it's not clear if that delay will be um, as a result of if that delay could amount to a breach. We want to ask how long an installation of this nature would normally take. And if we're struggling to get an outcome of this, we might want to consult what's it called, an expert. And is that expert that will tell us, okay, yes, so there's been a breach here, there's been no breach, everyone's okay. Yeah. And if it's been determined that there's been a breach of this and it has increased the costs of the service because it took too long, then we have to be sure that that's not as a result of what the vendor, what the trade did, what the service person did. So she may be able to claim damages for that delay. For instance, if due to the delay, she had to put her mother in care or she had to take her mother elsewhere, lodge her somewhere like a hotel or a hospice, she may be able to claim for that. So the final point is the point of cost. And I want us to talk about that when we get back from the break. I don't know. I think I've held you on for too long here. And I know many of you would want to go on break. So, well, let's go on break now. When we come back, we'll talk about the issue of cost and then we'll come to a conclusion on this. So, I'm looking at the question here. So, there is no statement here. Uh, Description and quality. So because there are no statements made, what we're trying to do is to fill up the statements based on what a reasonable person, what their conversations would have been. So you can say it's not clear on the fact what the statements made to how was okay. It asks about legal position in relation to quality and description. How should we structure in question three? Is it question three? This is question five. I'm trying to be sure, Twen, that I understand your question. Because you said for question four, it says legal position in relation to quality and description. Yeah. For you to talk about the legal position, you need to talk about sections 13 and 14. Okay. Now I'm looking at the other one, the one on Mary, on any available remedies. It's the same way you need to structure your answer. Because at the end of the day, when you're answering question three, you will be given an advice. And to give an advice, you need to go through the motion, talk about sections, description, talk about section 14. And it is when you've concluded on that that you now want to talk about acceptance, is it deemed acceptance, etc. And then you want to advise. So, Tuan, yeah, the structure is similar. You are discussing the same issues. So structure it however you want to be. Just make sure you discuss quality, you discuss uh description. Let me turn on my camera. So make sure you discuss quality, you discuss description, and you will be fine. And then you've talked about um acceptance and remedies as well. So now the next question I'm seeing here, it's a break or answering sessions now. Is it a okay? It's not a break yet. I want it to be at 12:55 that we go on break. S- okay. Time in Hong Kong is 8:55 now, I'm assuming. So we should be back by 9:10. Yeah, I think we should be back by 9:10. So you can leave now. Yeah. Come back from our short break. I know that was quite short. My camera, yeah, it flickers on and off. I think it's something that's got to do with the Wi-Fi. But think I think when the Wi-Fi drops, it switches off and on. Oh, yeah, I think we're back on. So looking at the comments section, okay, let's start from the top. Yeah, so there's a question about if the facts are not clear on something, should you make it clear and then consider alternative scenarios? So it's not clear what that is. So if it is A, this is the answer to that. If it is B, that is the answer. So I hope that answers your question, I think. So the next question is, could you answer after a break? Is there any section concerning time? Like yes, you need to rely. No, if you're talking about consumer contracts, you're talking about you need to use the CRA. So there's a provision there on time. We're going to get into that. I think we stopped at where did we stop? Yeah, so reasonable time 52, section 52 3. Section 52 3 is the relevant section on that. 52 2 also it provides that when okay, I want to be sure I've read the, so if not do it, so you don't, so it would show that you're confused. If you're talking about a consumer contract and you're applying SGSA, even though we've got sections in the CRA that applies to consumers. So when answering B2C questions, I might have missed, yeah, time-related case, channel. Yeah. So the authorities, the cases are still relevant because it's common law. And what happens is that the CRA has provided for a higher level of protection for consumers. So those cases are still relevant. But be sure to explain the cases, uh, explain that different sections apply. I think it's just yeah. Someone is asking for a guidance, and I've said this over and over and over again in this revision that we we don't want to give you a guidance because it would stifle your creativity. It would stifle your confidence in yourself because we want to see all ways you're able to structure this. And like I said, we learn from you as well. So if we give you a structure, how are we going to learn from you? No, no way. We won't be able to learn. So, okay. So you're saying, sorry, you're slightly confused on the possible chance you will be tested on B2C, as then this topic wouldn't be SGSA, but would be a full CRA topic. Yes, you're right. So if it's a B2B contract, that's the SGSA. If it's a B2C contract, that's the CRA that applies. And you might also want to refer to the regulations, the 2013 regulations that provides for information to be provided. See the by to the consumer before the contract. So those provisions of the statement made by this trader, by the trade, will form will form a part of the contract. Yeah. So it's a no brainer. If it's a business to business transaction, SGSA. If it's a business to consumer transaction, SGA. Not SGA, sorry, CRA. CRA, CRA. So let's move on and talk about time. We've talked about reasonable scale and care. Now let's talk about time. And I think we've also talked, yeah, let's continue to talk about time. So under the CRA, section 52(3, that tells us what a reasonable time is. Remember, section 52(2 said we would expect this to be done within a reasonable time. So sub 3 is giving us more guidance on what a reasonable time could mean. So it says it will be a question of fact. We want to ask what was discussed between Karen and John at the time of the fitting, or even prior to that. Was it made clear that the work needs to be completed within a specified time because of her mother's condition? The authority you cited in the comment, Charnock's case versus Liverpool, The claimant took the car to the defendant's garage, I said that, and then within 8 weeks, it took longer, and the court said, yeah, that's not good enough. So section 52 to section 53, 52.3, those are the relevant sections. Um, what we want to ask is on a reasonable time basis, how long would that normally take? And I think we've talked through these. I've talked about section 54.5 before we went on break, as well as if the cost of the service has been increased by as a result of the delay, she may be able to get the claim for the cost she has incurred. And we can have a look at section 54 sub 7 on that. So a combination of sections 52 and 54 should get you there in really about when it comes to time. So now let's talk about cost. In terms of cost, if the charges or means for assessing that is not fixed by contract, we we need to ask, as the trader, has John provided any information on as demanded by the CCICA regulation, that 2013 regulation, has that been provided? If that has been provided, then we can say there's that implied term that this will be done in section, if it's not provided, rather, we'll be relying on section 51 CRA that she will pay a reasonable charge. Now, again, reasonable, what is that? How do we measure it? It will depend on the fact. We will look at what estimate was made. In this case, how much was we're looking at the wrong question, aren't we? How much was the estimate? 3,000, I think, and then he was giving her 5,000, which is crazy, isn't it? So that is outrageous. We know that quotations are generally seen as fixed prices if they're accepted. But in this case, I think he said he used the word estimate. So that's very difficult for us. So what we need to do is to consider what a reasonable person objectively would pay for this. The courts will think objectively about what the discussions they've had and see if it was intended to be a fixed charge. And the case for that is Sykes and Packham rather. So there's the authority of Sykes on if they intend to be bound by it, if it's meant to be a fixed price. And there's also the case of Croshaw and Pritchard. Um, if it Croshaw, yes, thank you for that. So the use of the word estimate does not preclude the contract from being a fixed price. So the fact that he's saying estimate, and we can see in this case, I think it's the next one. The trade was trying his best not to say anything definitive. Yes, you can use the cases because remember the 2015 Act is very recent and it's just really difficult to what's it called? It's difficult to get enough cases on that. So because this is a common law related, yeah. But if there is a situation where more protection is required for the consumer, you might want to distinguish, but that doesn't happen here. So your Sykes and Packham is still relevant. Crochet is also relevant. I think there's one more of that's in the slides. So moving on. She needs to have special bathrooms to justify that substantial increase in the charges applied. They cannot, can they be justified? If they cannot be justified, then it will be argued that it's unreasonable. John has explained that it was because he couldn't find workmen. But let's think back to the case of that car, car, the 8 weeks, etc. And the court said these are some of the things that need to be factored in, Charnock and Liverpool. That these are some of the things that need to be factored into the contract price. It shouldn't affect the parties. So she should be careful not to pay the full £8,000 because if she does, and I think it goes back to the question that was asked about mitigation, if it affects a consumer. So she should be careful not to pay the full 8,000 price as she may be seen to accept the reasonableness of this charge. Remember, this is different from deemed acceptance. in relation to goods. But this is really about her saying this is not reasonable and then going ahead to pay for it. Why did she pay? It may be since that she's accepted it. So we the conclusion here is that the bath and the tiles are in breach of the implied terms under the CRA, and if they're not of satisfactory quality or fit for purpose, right, those are in breach of those provisions. Also, there's an argument for those things not being installed correctly, and that's also a breach of section 10. Yeah, sections 11, 9, and 10. So the terms impose strict liability when it comes to a consumer. She can ask for a repair or replacement of any faulty materials. In addition to that, the installation, if it's been carried out in relation to poor, not done with reasonable care and skill, in the standard you expect from a reasonably competent bathroom installer, if that's what is causing the leak, then there has been a breach as well. And the breach of this nature entitles the consumer to ask for a repeat performance or a price reduction. So what are her remedies? That's the are right. So she's able to ask for a repeat performance or a price reduction. And she also may be able to claim common law remedies, your damages for any loss or damage that has flowed from the bridge. So, as someone got injured as a result of the broken tiles, as she had to put her mother in a hotel or somewhere else, or as she had to pay extra to use someone else's loo. In that case, she may be able to claim for that. But remember, the damages claim must not be too remote from that bridge. It has to be linked. So I want to have a look at the questions you've asked before we move on to the next one. Yes. So CCI thing provides that you need to give consumers information. So it's the 2013 regulations. You need to give them information about what you're doing um, with what the product is, and that's just to ensure that a consumer is protected. So if that information is provided, then it will form a part of the contract. So let's look at the B2B equivalent, in which case we'll be applying the SGSA. Because I think there's a question like that that came into the chatbots, uh, not chatbots, the chat box. So yeah, I'll give us a moment to read Gloria's scenario. So, is there anything striking? Reading this, can you pop it in the chat if there is anything striking that you think you should pick on in your discussion, in your analysis, in your application of the law? Just pop those in the chat. Okay. No, you won't. You won't be tested on that, Chung. Yeah. So, what are the key things you should be discussing looking at this question? I'll check one example here. He's saying I would suggest a figure of 100,000, but don't quote me on that. So we see that he's trying to be big job, won't be cheap. Good. Yeah. Keep more of that coming. Don't quote me on that. He's trying to be slippery. He's trying to be slippery. Oh, big job won't be cheap. No more than 6 months. Good. Good. Yeah. Fluctuates. Yeah. Um, tend to fluctuate a little. So yeah, labor does. So he's just trying to not. And you see that he's deliberately trying to do something sneaky there. You want it done professionally. Yes. Yes. Good. So that's talking about the duty. Okay, let's see. I think there's more coming in. Accept its terms. So she accepted the terms. Yes. Yeah. Any possibility to have faulty parts rather than bad workmanship. Yeah. Notice that it disappears for long term, for long periods. It lives in experience. That doesn't matter, but it's something that needs to be discussed. You need to apply nettleship and Weston. Yeah. Yeah, and she made a representation to him again by the start of March, but the contract has already been concluded by then. So does that hold any weight? The contract was concluded before, right? She accepted the terms. Is she adding to the terms of contract if they've not agreed on the time? So yeah. All right. Now, what is the starting point? What do we need to do? We've been asked to Um, advise, have we, yeah, advise her of any rights she may have in respect of the building work, I think. Is that the one? Um, advise her. So what's the starting point? Yeah. B2B, brilliant. What's the relevant legislation? SGSA, brilliant. So you've narrowed those two down. You'll be discussing them, of course, saying the situation concerns this between two businesses. It remains for the purpose of goods, their glorious trades, businesses, etc. Good. Yes. So the first issue is the nature of the contract, is predominantly service. That's the substance of the contract. The goods, provision of the goods will be ancillary to that. So we need to get more information from Gloria to confirm the wording she agreed with Jack in their discussions in relation to the work to be carried out. And we need to know, are there any written agreements made? Is there any writing that can help us understand what was discussed? It looks like um, Jack is trying to be very sneaky. He's trying to be very evasive. He doesn't want to be held down on anything. And I think the court will take cognizance of that. So now, the main issues that I can think of in this case are four. The first one is, has Jack performed the work in accordance with his obligations in relation to the standard? Has it been done to the right standard? That's the first issue. The second one is the issue of time. It took 7 months when there were indications that 6 months should be about the right time to complete. There's also the issue of money. And the final one is to advise Gloria whether she has any remedy for the loss she suffered. So for every question on SGSA, sale of goods and services, you want to ask those main questions. There will be something about the quality of work done. There'll be something about time. There'll be something about price. And there'll be something about is it the goods thing. Yeah, the goods. And you will want to advise on the remedies. So let's get started with the first issue. If Jack has done the right work to the requisite standard, what we see here is that Gloria says she found the lighting doesn't work. The rain leaks in from the window, and the toilet will not flush. So the question we want to ask ourselves is this a kind of quality standard you would expect from a work like that? And we're not sure about what caused these defects. If they have come about not because Jack didn't do it well, but because he bought the wrong product, then it might be that it's not liable for under the SGSA in relation to that. So If it's from an unrelated source, not the product, not what he has done, then he's not, we can argue that Jack is not liable. But even if the defect in this case relates in some way to his work, it could be as a result of the faulty product he has purchased, and that won't be because of the incorrect installation of the product. And in that case, she may not be able to recover without expert analysis to tell us what really happened. Is it because of the product or is it because of the quality of work done? So we see that the windows, toilets, lights that are supplied and fitted, they have to be of satisfactory quality. And the relevant section for that is section 4 of the SGSA 1982. We said this is a strict liability provision. So it doesn't matter that Jack did not know or he had no intention of making that mistake. He's strictly liable for supplying goods that are of good quality, So, like I said when I was presenting, I said section 3 or 4 could be examined. But you see here, we're going straight into section 4 because there isn't lots to be said about section 3, which is about the description of the goods. I don't think that there's been any representation of that. Yes, section 13, 14, and 15 will also be discussed. You're right, Sham. Yeah. So moving on. Section 4 carries its strict liability. So a breach will mean that Jack is liable regardless of any fault in his actions. If the products are faulty, then it's quite unlikely that they'll meet the standard of a reasonable person. The court often, what they often do is to have regard to the general factors found in the definition section, definitional section of the Act, where they're thinking about satisfactory quality. So you know all the works, fitness for all purposes that are the goods are commonly supplied, no minor defects, appearance and finish, safety and durability. Here, in this case, if there are faults in the way described, they are unlikely to be considered satisfactory quality. If those things, if the appearance and finish is faulty, if it's not durable, that is not, it's likely to be a breach of that section. So if it is the faulty products that cause the defect, it will be liable for the damage caused because it was the one that supplied that to her. She didn't buy those herself. Now, talking about the windows, toilets, and lights that seem to fail in the, well, why we bought those for? To use them, but they failed. It is difficult to see how a reasonable person would consider them to be of satisfactory quality. They're not working. So what are they on about? And if goods are not fit for the general purpose for which they are commonly supplied, they are of unsatisfactory quality. The authority for that is Balmoral and Borealis. So it's a really difficult one to disprove here. It seems that the goods supplied under the contract are of unsatisfactory quality. Now, moving on to the price. Uh, not the price on the sections, section 15, 14-ish. We're talking about price as a metric for measuring the quality of the goods. In this case, the price paid, general or overall, seems to be significant, so that will raise some expectations about what to expect. The authority on that is Rogers and Parish. I've spelled that before. In this case, there appears to be more than only one minor defect, which is unlikely to meet the standard expected, bearing in mind what they discussed and the price she has paid. Again, the authority on that is Clegg and Anderson. The party would certainly expect that what these things are should be durable and last longer than they have. So they should last a reasonable period of time. And we've got the authority of Lambert and Lewis. And if you can observe the pattern here, we're using those cases we use under the Sale of Goods uh, Act because this is really about goods being supplied. So sections the cases on sections 13 and 14 are very much relevant, but we're focusing on section 4, which is similar to section 14 of the SGA. So the cases decided on those are relevant. Now, any breach of section 4 would be a breach of a condition. Again, under the SGA, it is a breach of a condition. And that means he would entitle Gloria to repudiate the contract and treat it as if it has come to an end. In addition to this, she could also sue for her losses under the agreement, and that would inevitably include damage caused to the property, ruined plaster, ruined carpet. If any decorations has been ruined, any paintings, we'll be thinking about remoteness as well, but it looks like some of the things she has suffered in this case are clearly linked to the contract. And she also may be able to recover for the cost of any consequential loss. Maybe she has to pay money to repair. Maybe she has lost profit as a result of that thing not being done to standard. Now we see that Jack is acting in the course of business. What that means is that there's an implied term that it will exercise reasonable care and skill. So now we're moving on to section 13 that Sean put in the chat. Sean is ahead of us. So now we're here with you, Sean. So section 13, reasonable care and skill. Remember the cases on negligence are relevant here. And because negligence requires a proof of damage or something of that nature, it is not a strict liability issue. And as such, Jack will only be liable if he performs with some element of fault. The standard required by the law under Section 13 is that Jack must exercise the standard reasonable of a competent profession of his status. So, what would a qualified person in his position do? And the authority for that is Bolem and Friend. We see that the courts have in the past been very reluctant to imply a standard about guaranteeing results, and the case for that is Stake and Morris. And I also saw the other case, one of you pop in there earlier. I can't scroll back to that, but that also seems to be relevant. I checked during the break. So Stake and Morris, where failed sterilization, where some um, they were they went to the hospital to not be fertile anymore, and the surgeon failed to warn them that there may be failure. You may still have children, and the court awarded them um, remedies, money for the cost of raising the child up until he was 17 years old. And I think there was this other claim made by the claimant saying that she also wanted to recover remedies for the pain of labor, for the pain of pregnancy. And I think the court said the benefits of having a child outweigh those pains, so they weren't going to comment on that. But I think Lord Denning said that there should be nothing presuming that you are entitled to a guaranteed outcome, really, in cases like this. So no guarantees, no guarantees. The reason damages was awarded in that case is because they were not warned of the risk that the surgery may not work, so they could use other alternatives to support that. But we know that it is possible for the parties to guarantee a successful outcome in their contract if they use words that are very clear, unmistakable, and that leaves no doubt as to that being the case. So they're very clear that this is the outcome we want, and we want that to be guaranteed. So the authority on that is platform funding, PLATFORM funding, and Bank of Scotland. I think I talked about this earlier. So in this case, it doesn't seem like there's been a guarantee given, but that still doesn't preclude the obligation to do what a reasonably qualified person in that situation would do. So they're not getting a free ticket out of this liability. Jack is not getting out of it because Jack has not guaranteed the outcome. Um Clearer guidance needs to be given about the standard of care required of him. But even at that, it still looks like he's liable because he has failed in his duty. Incompetence. Now, this is when we talk about the standard of care expected. The incompetence due to inexperience will not amount to a defense, and the authority on that is Nettleship and Weston, where a learner driver is held to the same standard as a qualified one. So the fact that Jack leaves his inexperienced workers on the job will not protect him. They will all be assessed as reasonably competent members of the trade they profess to belong to. In relation to medicine, there may be more than one way to treat a patient. That a doctor chooses one cause over the other is not negligence if he can show that a responsible body of doctors would agree with what he has done. So the field will be relevant. The field is quite crucial to the discussion. So if someone who professes an expertise in a specialist area, e.g., maybe a consultant surgeon, a consultant pediatrician, we would expect them to meet the standard expected of an ordinary member of that specialty. And the authority on that is Maynard, Manard. Yeah, Samuel and Davis. Thank you for reproducing that, Lord Chi. So the case on specialist branch and that still being the ordinary, uh, a competent member of that specialty, the authority on that is Maynard versus West Midlands Regional Health Authority. So even though it must be noted in this case that there's not a great deal of authority outside of the medical field, all of these cases we're looking at are from the medical field. There's this authority, Greaves and Bainham Milky, Greaves, Greaves, which is different from the other authority we cited earlier. So Greaves, in that case, the court refused to impose a higher duty of care on consultant, expert, structural engineer. The court required them to demonstrate the reasonable competence of a structural engineer. So it's just the court being reluctant to hold that higher level because the risk of that is then other people in the future may be held to such a high standard. And there's this authority as well in Matrix Securities and Theodore Goddard. There was no raise standard as well in relation, and this was in relation to solicitors who profess a higher level of skill and experience in the tax field. The court said they will be measured according to the competence of the firm at that level. So an air piercer was not judged to be someone that gives you piercings where you put your earrings and all that, was not judged to be by the standard of a surgeon when piercing a hair. So the court is just really trying to be very, very careful, not imposing onerous um, too demanding duties on people. And the authority for that is Phillips and William Whiteley. So what we need to do in this case is to establish if Jack has he claimed any specialism, and if he has done that, it would be expected to perform to the standard of a reasonable person within that specialist. So he would be expected to perform as a reasonably competent builder if he has not held himself out to be a specialist. It may be that he is not a specialist electrician or window fitter or plumber, but if such things are so technical and difficult to install that a reasonably competent builder cannot do it, instead referring it to a specialist in that field, then Jack would have breached that standard. And I remember talking about negligence. There's there could also be some claims not related to this, but something worth knowing to you all is that even as a specialist, you may be liable for failure to refer. So if you know this is something that is not within your power, you may be liable for failing to refer to the right person. So once again, it's important to have a clear report provided by an expert as to why each of the defects arise. So, is it because he has failed the reasonable practitioner test, or is it because it was for another reason? So that expert may be able to offer an opinion on whether the installation was carried out to the standard expected or not. So the defects appear to be basic. It's just a bathroom, fixed not bathroom, we're done with that. Do fix lightings, window leak, etc. Those appear to be basic and fundamental that it is unlikely that he has met a competent standard. The windows leak, the lights don't work, and the toilet wouldn't flush. So before I look at the implication of a breach of Section 13, I want to see some of the questions you've popped in the chat. You said, may I clarify? So if the light and window toilet are faulty, he is liable, but under Section 4, per ye. Do you get it? Because this is supply of goods and services contract. So if he has supplied defective goods, he's liable under Section 4, not under Section 13. Does that make sense, Puyi? Yeah. So different sections, but all of these are still covered by the SGSA. And as well, when it comes to a consumer, all of those are still covered, even though they repeat the provisions of the SGA. So he's liable because he's the one that has supplied it. It will not be liable if the lady, Karen, procured this independently and gave them to him. And we've got an expert to prove that he actually, it was the goods that were defective, not his installation. And the reason he will not be liable for that is because he did not procure the goods. But in this case, he did. So Section 4 is relevant. So I hope that clarifies it. So any authority for that supposedly reasonable refusal. I'm not clear on that point. Could you elaborate? Reasonable refusal. Not clear. Could you clarify? So the next question here is the only registered are allowed to do such works and they have given it to someone else. So now maybe we're talking about the breach of a specific statute if that has been breached, but that's not the focus of what we're doing here. And I want to mention that as well, that resist the temptation to bring in things that are not relevant to the sale of goods. So there may be other issues. With the health one, there may be some things about the health one, but yeah. Okay, so you said if reasonably competent, workers would also refuse and didn't refer to specialist. Oh, so failure to refer. I'm just talking about that in under the topic of negligence. So if you as a medical doctor, you've observed that a patient has got some issues and you know that's beyond your power and it's actually beyond your expertise, you may be liable for failure to refer, but that's not relevant to the purpose of our exam. It's just something I mentioned in passing. If something like that interests you, it fits more under the heading of negligence than under what we're talking about here. So it's a broader topic. Great. All right. Yeah. So hope I've answered that question. When you say only registered workers are allowed to do such work, then there would have been a breach of a statute, which is extraneous to what we're talking about here. But that's not what's being examined. So yeah, don't dwell on that. We're not going to examine you on someone giving work to a person that is breaking the law. That's not the scope of this unit of this course. So now let's talk about the implication of Section 13. What is the implication? Is it a is, is it a condition or a warranty? Anyone wants to comment on that? Is this a condition? Is it a warranty? What's the implication? If it's about condition, we know what the implication is, but what is the implication here? Yeah, okay. It's an innominate term, so that means that the remedies available to Gloria will depend on the impacts of the breach, the effect. So the contract purpose was for the conversion of a derelict building into business premises, and we're not clear if the defects are so serious as to deprive Gloria substantially of the whole benefit of the contract. From the fact, a lack of toilet facilities, if they are the only toilets, could pose a danger to her business. You know, people want to be able to come to a restaurant, use it, and then relieve themselves afterwards. So that could be a problem, couldn't it? And the lights are not working as well. That's not good enough. It might put our business in a bad light, and that would just mean people don't want to come there. So, yeah, it's a difficult one to pin down in the case, in this case. So, lack of lighting and the toilet could be a health and safety issue. If it's a restaurant, people want to come into the place and be able to have access to all the things they require. So it seems like it could defeat the purpose of the contract if it's a self health and safety issue. And now you're saying, well, on the fact it's not really clear what she has suffered, but you might offer alternative scenarios and say if they are not fit to be used as business premises because of these defects, then we would say it's a breach of a damage condition rather, and only if it's appears to have deprived Gloria of the substantially the whole benefit of the contract, will she be entitled to repudiate the contract and treating it to have come to an end and sue for her losses? The authority on that is Hong Kong, Fail Shipping, and Kawasaki. So more likely, in this case, it doesn't seem to have deprived her of the. She still has the restaurant, doesn't she? But it's not what she expects it to be. So because it's an innominate term and the breach is not that devastating, we can say it should be treated as a breach of a minor term, a warranty, in which case she'll be able to sue for damages. So there are secondary issues with the work because it took longer than they anticipated. It was stated that it would take no longer than 6 months. Gloria would want to argue that this was agreed as a term that it would take no longer than 6 months and finish by August. But even if this argument succeeds, in the case of United Scientific and Burnley Council, the court said that time would not normally be of essence. It will not normally be a condition of the contract unless the parties have stated that it is, or the nature of the contract is the one that suggests that time should be. So if you're trying to um, rent a room for school session, time is of essence for that because session is very specific. But in this case, it's not really clear whether time is of essence. So, but the argument will be, Gloria would argue this, and Jack would say, no, there's no agreement as to time. The wording they've used is not very certain. In those circumstances, the court will apply section 14(1) that says that when no time has been fixed, everything has to be done within a reasonable time. And here we would argue that the parties agreed on the conversion to take 6 months, which could be reasonable looking at the terms. If this is not a term of the contract, then it will certainly be taken into account by the court in thinking about what a reasonable period of time for the repair could be. Looking at the case of Charnock and Liverpool Council CC, a repair that took 8 weeks. Remember that car case we talked about, and the court said the extra time, extra 3 weeks, was not a reasonable time. So Gloria needs to ask why the conversion took longer, and maybe there were initially discovered issues that needed addressing. If this was due to factors outside of the control of Jack, it may be that he has met the requirements under Section 14. But now, in this case, we saw that Jack disappeared, left his workers there, inexperienced workers, and that is not a good reason to delay the work. So we can say there's been a breach of that term because he went away for long periods of time. Again, it will be helpful for Gloria to know what a reasonable period of time for such conversion would be. And if we struggle to get that, we might have to ask experts on that. If Jack is in breach of the time condition, it is likely that Gloria may have to put to expense. She might be made to spend some money she had not planned for. Um, she might have lost some of the profit she's expecting, and she may be able to claim that or lost revenue that derives from the bridge. But again, remember, there's the issue of remoteness. So she did contact Jack later to say the deadline is a deadline. But like I said when we're reading the question, it's not up to her to come mid-contract and alter the terms of the contract. If this was something they said before the start, that would happen. But in this case, it is not on her to impose a completion date if the contract does not state that. This is after the fact. Unless that the date she's talking about is reasonable. You can think about the case of Charles Rickard and Oppenheim, where time was of the essence, but performance of it was waived. And again, that's just a line to say in the case of Rickard, this it was waived. That's very succinct. It's very short. We're not going into too much details about the case, and I'm explaining that for the purpose of the student that was asking if you need to state the facts of the case. At times, you find that it's often distracting when you do that if it's not relevant to the discussions we're having. So, moving on, in Oppenheimer, time was held to be of essence, but it was the performance of it was waived. It was possible to reinstate a new finish date and still get stuff done, well, upon a reasonable notice in that case. Instead, what the courts have done is they thought about whether they took a reasonable period of time in the circumstances, and they also may view this in the light of their discussions, what was said. So she sent him a message saying, time, did he respond? Was there any renegotiation in relation to that? And we can also ask, did Jack raise any issues over his ability to meet the date? He didn't. He just said he's going to do it professionally. He made all those bustings. So it's not very clear, but if we're struggling to know whether this, we might have to appoint an expert. But before talking about appointing an expert, you need to have at least tried to answer the questions, try to argue, try to apply the cases, and say it's still not clear, and that's when you may want to consider what time is standard as the time to complete a task of this nature. So the final issue is the cost. And the relevant section is section 15 that says that if the charge is not fixed by a contract, there has to be paid a reasonable charge. And what is reasonable again is a question of fact. In this scenario, it is clear that Jack used lots of deliberate attempts to use vague language because he knows that it's going to come in the future and demand £25,000 extra. That's a whooping lot of money. So when he was saying price could be around 100K and say, don't quote me on that. What does it mean? Uh he's the expert. He should be able to let be quoted on stuff like that. So we know that generally quotations are considered as fixed prices if they are accepted, but Jack did not give a fixed price in this case, and this is clear on what he said, and also relying on the case of Sykes and Packham. But in determining what reasonableness is to the court will have reference to the term they use, what they said about the estimate being 100,000. So something close to that is what the court will land on in determining what price should be paid. So we have the case of Crowshad and Pritchard that also mentioned, and there's also Way and Latila. Those are some of the cases in this SGSA. They're not very many, and I think that's really good. So you're able to just pick the ones to memorize and use in the assessment. The courts have made reference to the market cost of such things like this. How much would someone be expected to pay for things like this? What's the going rate? So Gloria should ask about this, ask around, tell us what the cost of conversion could be, and she should place that claim before the courts. That would be very helpful in guiding the court on how much the charge should be. So the time could also be linked to the period of time it took to complete the work. But if this delay was due to Jack's fault, then it's primarily liable for that. That shouldn't be a cost that is shifted um to the consumer, to Gloria. If it's found that the work took longer and that increased the price, it will not be able to recover that for the extra if it was due to his fault. And if the bill increased because of poor workmanship or inexperience of his staff, Gloria will not be able to pay for the increase. She doesn't have to pay for that. But if she warned him that the bill might increase due to increases in materials, which was the case here, that could be something that would be considered by the court. Well, we could see there in the meantime that she needs to be advised not to settle the bill in full. This could be seen as acceptance of the charge, and any payment she makes on account should be stipulated, and that will be subjected to any proceedings between the parties. So I'm trying to have a look at the questions. I should just thought, yeah, she can claim for damages for the defective materials, claim for damages, for the other issues as well. Should we discuss 4.2 and in section 13? Yeah, that's the point. That's what we've done here. We've said it could be the bulbs, they're defective, or also it could be the installation. So since we're not sure, we're arguing both, and it's up to the court what it accepts. Yeah, yeah. So that's a really good argument to make, Lord Chi. You could argue that food hygiene, if there's no toilet nearby, that's problematic. If there's no toilet nearby, that's problematic. Yeah. So now I want us to quickly have some look at the slides for is Nemo. So the next topic is Nemo. I don't know if you're tired, but I think we should get cracking so we're able to cover lots of ground. So let me my 3, 4 Nemo. So at least let's see where we get to here. Remember I said on Monday when we started in relation to section 12, the discussion is the rights of the parties among themselves. Section 12 is about when someone has sold something that is not theirs. So it's a sale by a person, not the owner. And it's a question of what are the rights of the parties. But when it comes to the Nemo, that principle, it's really about who the owner should be. So it's a question of ownership. You can't give what you don't have. So who's going to own these goods now? And this happens often in cases where an innocent person, two innocent persons really, have been affected by a rogue and the rogue has disappeared. So these are some of the examples. You take your car to a dealer saying, find me a buyer on sale for less than £1,000. So they've sold it for £1,200 and they disappear. So they followed your instruction, but you don't get the money. So you're an innocent seller, I think. And then there's a buyer that is also innocent, but the rogue has disappeared. So in that case, who owns it? And in this case, they sold it for £600, contrary to your instructions. Who owns it? A diamond ring is stolen by a thief who sells it to your friend. Who sells it to you? Who owns that? So let's see. Think. So you're asking if Nemodat is an essay? Yes, it's an essay. And it is also an essay in the receipts. So it's an essay question. It's an easy one to pass, really, if you ask me. So let's look at the second example. You buy a car from a dealer on hire purchase terms from Chipo. So it's not yours yet because you're still paying hire purchase payment. So you've decided to sell it off and as a form of part exchange. So you're exchanging the van and the car, you're adding money to it to get a new one. And that is sold to a new customer on a new hire purchase agreement. Who owns it? So it's questions like this that we're faced with when we're talking about Nemo that. So look at this situation. You have an owner, the claimant, and someone else that shouldn't get a hold of the item, get a hold of it and sell it to the defendant. And B1, buyer one or B1, they've taken off. They've run off into the sunset. So B1 does not have title. But now who owns it from C, the claimant, and D, the defendant? And what will happen is the owner, the claimant, seeks the return of the property under Section 21. Again, if you're answering a question on this, the starting point is Section 21 that really makes the provision on NEMO that. So the critical issues to consider in answering a question on this, especially if it's an essay question, is why? Why do we have this principle? Why do we have the rules and the exceptions? And the main reason we have it is for the court to make that hard, tough decision between protecting one of the two innocent parties. So two people are innocent. Someone has got to suffer the loss. So it's a very hard decision to make. And this is a principle consistent and coherent. In answering this bullet point two, you will have to go through the exceptions. If it's an essay question, you will have to go through the exceptions because it is through your argument on the exceptions that you'll be able to show that the principle is not consistent, it's not coherent, it doesn't make lots of sense. And one of the judges said it is just based on technicalities. It makes limited sense. So, does the application of this principle demonstrate adequate and fair protection of both parties' interests? No, it doesn't. It has to choose one person to protect. So one person is often left high and dry, and that person is not the rogue, is not the person that has caused this issue. And you want to ask, are the rules fair based on culpability? It's not based on culpability because we see inconsistencies in the decisions of the courts on this. Now let's look at this quote in one of the decisions, Bishopgate. The court said, in the development of English law, two principles have striven for mastery. So one is trying to be the master, the other one is trying to be the master, and it just goes on and on and on. So the first of the principle protection is nemo dat quod non habet. No man can give better title than he himself possesses. Literally, nemo that means no one gives who possesses not. It doesn't make sense, but because it's Latin, that's a literal translation. So the second principle that is striving for mastery with the first one is that a person who takes in good faith for value without notice should get good title. So one is trying, the first one, Nemo that, is trying to protect the right to property. And the other one is trying to protect commercial certainty. You need to be able to go out there, buy something from someone without worrying about is it the owner that sold it? Is it the is this a rogue? So commercial certainty and ownership right, they clash. They're striving for mastery. And we've got this interesting quote by the court in this case, Lake Barrow, that wherever one of two innocent persons must suffer by the act of a third, he who has enabled such a third person to occasion the loss must suffer. But that's not what happens in reality, because the only person that is culpable here is the rogue, is the person that has created this issue. But more often than not, that person has gone off into the sunset. No one can see them. So what the court is left with to grapple with is to determine who do we who do we kick to the curb? Who do we make to suffer this loss? So, like I said, competing interest, the law is trying to choose between innocent interest. Should commercial certainty transactions be protected? So, purchasers take good title, or should the right to property be protected so the owner can get their goods back? The section, the relevant section of the SGA is section 21, which provides for some of the exceptions to protect and facilitate commercial transactions, as well as protect the innocent purchaser. The Crowther Committee, as well as other committees, have criticized Nemo that they said it's not based on equity, it's not based on justice, it's just based on technicality. So these are some of the points you might want to raise when you're writing an essay question on this. And when we answer the past questions on this, you see how what that could look like. So when you're tackling this problem, you need to consider whether you are focused on ownership and or remedies issues. So does the question require you to talk about ownership only or also rights between the parties? More often than not, you have to do A. But if you interpret the question, it could mean you have to do B as well. So does any buyer acquire title to the goods? And what are the rights between each buyer and seller? This will be relevant where a buyer has no acquired title. So what other rights are there for him to claim? So let's look at the section. Enough about talking about it. Let's actually look at the provision of the Act. So where the goods are sold by a person who is not their owner, the buyer acquires no better title to the goods than the seller. So the CRA does not deal with the Nemo that because it's a very tricky issue. Dealing with it with consumers is just going to open a kind of worms that they didn't want to be the case. So we have six main exceptions. If you have an essay question on these are some of the things you need to talk about, but make sure you're just not describing them. You're looking at the complex areas, and we're going to talk about some of these when we're answering the questions. So the first one is in the section itself, section 21, where you are exculped, you're prevented from denying that the seller has the right to sell. And the second exception is where there's been a disposition by a mercantile agent, an agent that is in the business of selling things of that nature. The third one is sale by under a voidable title, which has to be distinguished from sale by a a void sale, which is void outrightly. You cannot get anything from his void title. We're going to contrast the cases of Louis and as well as the Ingram and Little and see which one is the correct position among those two. Disposition by a seller in possession. If a seller has sold an item and you as a buyer, you've not gone there to collect it, you still let them have it. They're still able to pass good title to subsequent buyers. And also the same for a buyer. So if you're a buyer that you've not fulfilled all the conditions you need to fulfill under the contract, and the seller has let you have possession, even if you've not done all of that, you may be able to pass on good title as one of the exceptions to the NEMO that. And remember, we talked about this, the final one, on Monday, which is disposition of a motor vehicle under the Section 27 exception of the Hire Purchase Act of 1964. So let's start with Estopel. What I'll do is try to talk to the slides until 20 minutes past the hour, and then I'll give you 5 minutes to ask questions, and then we can continue from where uh, we left off tomorrow. Yeah, tomorrow. So the Estopel exception says that where goods are sold by a person who is not an owner, the buyer acquires no better title unless except the owner is by his conduct precluded from denying the seller's authority. And this goes back to the principle of extupel, the equitable principle that if you've led someone to have a belief that something is the case that is at your own detriment, you will be prevented from saying that is no longer the case. What will suffice to preclude the owners from denying? We see that in the case of Moorgate case, where Lord Wilberforce said, English law has taken the robust line that the man who owns a property, you're not under a duty to safeguard it, and you may sue for his recovery from anyone who gets it. So the principle here is not that you have to be extremely careful. That is not realistic. We shouldn't have to be careful with our items. Of course, in today's age, we have to, but the law does not require us to be careful. You can be just be yourself, and if someone gets a hold of your item, then they are liable for you can get it back from them. So look at the examples Lord MacNaughton has put here. He said if he loses a dog and someone sees it because he bought it from someone else, he think is the owner. It is no defense to say, "Oh, I didn't tie my dog down. I didn't put I didn't put a collar on it. I didn't keep it well." And also, if I leave my gold ring or watch on a chair in the park, on the seat in the park, it is no answer to me to say that I was careless with my ring. It is mine, it is mine. If I'm careless, no one cares. Why did you buy it? So these are some of the situations we can see with the Nemodat principle and the Estupel. So now I said something about the hire purchase agreement earlier. This is what it looks like. So there's a dealer who owns the car. Someone that sells cars, he owns it because he has purchased it from the owners. And a customer wants to have a purchase on hire purchase. The customer submits the agreement to the hire purchase company, and if they accept it, the dealer sells the car to the hire purchase, who owns it and then hires it out to the customer. So the customer continues to make hire purchase payments. He has possession, he drives the car, but he's not the owner. The owner is the finance company. Until he has made payment, he has paid all the money he needs to pay before ownership transfers. So you can see this authority here. There's a owner that sells the car to a swindler, and the swindler sends it to the defendant. So with this, we see that the agreement completed by the swindler to buy the car, even though before that agreement was accepted, the claimant allowed them to take the car away, and the court said there was no estopel, merely handing over the possession. So you see that there's a higher level of expectation demanded from the buyer. So in this case, you see that even owners that we can determine to be careless, they're still able to get away with this by saying, yeah, so there's no estopel by conduct, giving them the car, and the logbook did not mean you've given the car to, you're not, the estopel doesn't happen. So there's a high threshold you need to uh, comply with to be able to claim under this. In this case, the claimant sold the car but did not register it with the HPI. The HPI is the central repository where lots of hire purchasers, companies log cars on hire purchase to. So if you as a dealer wants to buy a car from someone, you're able to check, and by checking, you can see if the car is subject to hire purchase. But in this case, they did not log the car on that central register. And the court said they've not been careful. Nemo that still applies, so they're still able to claim the car from the innocent party. And this is a rather an interesting one because there's a degree of culpability of the owner. So in this case, the owner of a truck that I use for business wanted to buy a new car, but he couldn't afford to buy the car. So what he did was to pretend as if he sold his truck, his business truck, to the dealer, and he the dealer now sold that truck to the hire purchase company, Eastern Distributors. And because they sold the car to the hire purchase company, the car was now hired back to the owner on hire purchase. So the van has been transferred, it's their own. So the money that should have been recovered from this transaction was intended to be used to finance the new car he wanted to buy with the dealer. But I think the dealer informed the owner that, oh, the application failed, he couldn't get that, not informing him that he actually has sold the car, the van, the work van, to the hire purchase company. So the owner just continued using the van under the impression that it's still his own, that the uh, gold ring wasn't going to get all the money from the hire purchase company. But that's exactly what he did. So, because the owner thought the van still belonged to him, he sold it 1 month after the scheme, the scheme they arranged, and that was when Eastern distributors pursued. Uh, yeah, they sued the defendant Goldring, asserting ownership, and the court said because he pretended there was that grand scheme to defraud the Eastern Goldring, that meant that he's actually stopped. He's prevented because he went out of his way to be careless and do things that he shouldn't have done. And in this case, the court said, yeah, he's not able to benefit from that provision. So this is another authority, but I think I should stop now because I want to see if you've got any questions. We can start from slide. Not sure what slide is. I'll stop sharing now so I can see. We start from here. Um, we just discussed Eastern Gold Rings. So if you've got any questions, can you pop that in the chat? If you've got any questions, let us know. So I'll just pop a note there and say start from here. Nemo that. I was expecting that I would do more than that, but it's fine. So any questions, put in the chat. Like I said, it's an essay question in the assessment, so hopefully you'll be able to answer that with no wanted to raise money on that card, not that one. Yep, yeah. So that's slide 17, and we've got 12 more, 22 more slides to go, but we'll make progress. We'll make progress. So are you still with us here? Start on Friday. Yeah, let's see if you've got any. Okay. Which topic would be an essay question? Good question. In the main exam, you have a question on Consumer Rights Act, and it's in relation to that would be the essay question. So we have essay question on Consumer Rights Act and the name of that principle. But for section 1314, section 12, SGSA, risk and property, those are all essay questions. So you got 2 more minutes to ask any questions you have. And I know it's very late in the night in Hong Kong. So if you want to leave, you're free to leave if you've got no questions. Thank you all for engaging, and I hope to see you all tomorrow, where we'll continue what we've discussed today. So you're free to leave. We just got 2 more minutes to go. If you've got any questions, ask. You can send me an email with your questions. I know I still owe one person an email response. That's because I've been unbelievably busy these days. So hope to see you all tomorrow. Um, yeah. So I'll stop recording now because that's the end of today's session.